18.
18. Next.
Obligation.
Ma'am, please, Lordship. Lordship, therefore adjournment, Lord. Item number 9, Lordship, therefore adjournment. If leading comes as summary is out of station, Lordship, for some legal purpose.
As prayed for by
Lordship, I am
Mr.
appearing for the private respondent. We have not received a copy of the petition, Lord.
Mr. A.N. Sharma.
No. M.M. Zaman, Lord.
M.M. Jaman, on behalf of Mr. S. Chamare, list this matter
After this week.
after
This week.
Lordship, coming
next
on
week.
Monday,
Next week, on a date to be fixed by the registry. Stop. A copy. You have not received a
we have
copy?
not received a copy.
Give him a copy. Yes. Next.
Obliged. Lordship, I beg to mention item number 31.
Yes.
We adjourn.
Is there not received, Lordship? 31. As prayed for by Mr.
R. Karim.
R. Kalita, learned counsel for the petitioner, list this matter after 1 week on a date to be fixed by the
He's
registry.
on interim, Lordship.
Interim, if any, shall continue till then.
18 April.
18 April?
Yeah.
Alright. 18 forward. Next.
Item number 45.
Yes.
Back pain. Letter will be listed after 2 weeks.
Your name?
T. Ghosh.
You are for the petitioner?
R.R. Mujib.
No, you are appearing for the petitioner. As prayed for by MS?
Wait for me. R.R. Mujib.
On behalf of RR.
On behalf of R.R.
Respondent 2. As prayed for by MS R.R. Mujib, learned counsel for the respondent number 2, with consent from the petitioner? No. Then you please take consent and be present when the matter is called. Next.
The consent of other side, I beg to mention item number 22, Lord.
22.
22, Lord. Can the matter be fixed on 9th of April, Lord?
Alright. You are?
I am A. Dhanuka, Lordship, proxy counsel on behalf of SK.
You are for the petitioner?
Lordship.
As prayed for by Mr.
A. Dhanuka.
A. Dhanukar, learned counsel for the petitioner with consent of the other side. List this matter
9th of April.
on 9/4/2024.
There is an interim one.
Interim, if any, shall continue till then.
Another period, Lordship. That's to item number 63, Lordship. I want to withdraw this case, Lord.
63.
Lordship.
Supplementary.
Lordship.
Withdraw. In item 63, Mr. A. Dhanuka, learned counsel for the petitioner, submits that he has received instructions from his client not to press the bail application. Stop. In view of the aforesaid endorsement made by the learned counsel for the petitioner, the bail application stands disposed of on withdrawal.
Please, Your Lordship. I should have preferred listing and anticipatory bail first method. Anything, my Lord, tomorrow or day after?
Friday.
Madam.
Friday, huh? Listing. Yes. All the list. 468.
What had it? Lordship. The petitioner was.
Alright, CD.
Lordship.
You want to say something?
CD, Lordship.
CD, list on?
Lordship, next week, Lordship, 20 March.
23, 2024. Next.
Can it be on 19 or 21 like that?
Yes, can we have it on 19?
Lordship. Obliged to.
306. Alright. CD.
CD, Lordship.
Date
20,
Twenty.
Lordship.
4. 376 2 end.
Lordship, 23, 24.
May I please, Your Lordship?
376 2 end.
Yes, Your Lordship. Lordship, the matter.
PD.
Lordship, the matter has already been started. The trial is already going on. Trial is commenced, and the evidence of the complainant has also been recorded, Your Lordship.
In LCR, Lordship.
LCR.
Scan copy of the LCR.
Scan. Let the scan copy of the LCR be called from the court of
Additional Session Judge.
Additional Session Judge Langya through the registry of this court. Stop. List. Moitri.
After
2 weeks.
2 weeks.
2 weeks of the date diok na.
2 weeks. 27.
Obliged, Your Lordship.
Wait.
Yes. 366.
366.
Yes, CD.
Lordship.
When?
CD on Lordship 20, Lordship.
23,
23.
2024. Yes. 376.
Possibly with a difference, my lord. But can you
Possibly?
look at the FR page 9, my lord? Only once, my lord, for energy female.
Page?
9, my lord. Palpably, possibly, my lord, 354.
Page 9.
9, my lord.
9 is paragraph 8.
No. Page 9, my lord.
Page 9 is paragraph 8.
I'm sorry, my lord. 19. I'm sorry, my lord. One has been. I'm
Yes,
sorry.
19.
Extremely sorry,
Yes,
my lord.
yes.
19, my lord. It can at best or at worst be 54, my lord. Outraging modesty, my lord.
Which police station? Lakhimpur.
Yes, my lord. This is not Lakhimpur. Possibly, my lord, diary is necessary. Yes, my lord.
Diary is necessary.
Yes, because the allegations are 376. I admit.
CD, give a short date. Lakhimpur.
Lordship.
Next week.
Next week, Lordship, 18.
18. Highly obliged.
18th. Yes. 354, 323.
Yeah, please, my lord. My lord. There was
326 is also there, Lordship. CD, Lordship.
Yes.
litigation against present
CD, when can we have it?
Lordship 23,
23, 23.
19, my lord.
19.
All right.
Hello.
302.
302, my lord.
CD.
Against 22nd, my lord.
22nd?
Lordship.
CD, 22nd, 320.
Deeply obliged, my
CD will be necessary.
Yes, CD, next date.
Lordship 22nd, Lordship.
Lordship 120, Lordship.
Ms. Begum, 20?
20. 20.
20 করে দিবা দেই দিই 9 মেনশন করছি Yes, transfer petition.
Yes, my lord. Yeah, my lord.
Transfer from Dibrugarh to Nagaon.
Nagaon.
Will issue notice.
Because I am praying interim prayer is there.
Not
Because
today.
what happened, my lord? It is between the complainant is the son of petition number 1. It is between mother and son, and allegation is that son against mother. Not allegation.
All right, we'll give you short date and interim on the next date. Right. This is an application under section 407 of CRPC 1973 seeking transfer of CR case number 63 of 2019 registered under sections 120B, 420, 384, 294, 506, 34 of IPC from the Court of Judicial Magistrate First Class Dibrugarh to the Court of Chief Judicial Magistrate Nagaon. Stop. Issue notice returnable with date is not a party. Issue
complaint.
notice returnable on after 2 weeks. Yeah, after 2 weeks data. Returnable on 28/3/2024. Stop. Steps by registered post AD within a period of 2 days from today. Stop. List according.
Interim prayer may be.
Interim prayer shall be considered on the next date.
I am online.
May I please, your lordship? Lordship, there is a criminal revision petition, your lordship.
Which is the order?
Lordship, the conviction order is a page. The judgment is at page 41, your lordship. Starts at page 41.
Page 41.
Yeah. The judgment of the learned CZM Nagaon starts at page 41.
Which is the operating part?
Operative part, your lordship, at para number.
This is a conviction you are challenging.
Yes, your lordship. I was
In a revision petition, why?
Lordship, I was convicted. Then I preferred the appeal
before the learned session judge Nogao, the appeal has been rejected.
Where is that order?
That is at page 62, Your Lordship. Page
That is
62
the
of
order against which this revision is.
Yes, Your Lordship.
But against that order, you have a right to go for appeal, which is
Lordship, I was convicted by the learned CJM, then I preferred appeal before the learned session judge.
where is the operating part?
Lordship, at page 99, para number 55.
CRP 9. Page 90.
99. Second last page, para 55.
Yes.
May I read the Lordship?
Yes.
In view of the foregoing discussion and reason, this appeal is found devoid of merit and accordingly dismissed.
Your appeal has been dismissed. And against that, you have come in revision.
Yes, Your Lordship.
Ms. Begum,
Lordship,
is this revision maintainable?
how's it?
Minus 390.
390?
7 of CRT.
Revision will review. There is
Yes,
no
yes.
provision for second appeal.
Yes, I have.
CRPC.
Yes, correct. So we'll issue notice.
And LCR may be called.
Lordship, an interim prayer, Lordship. In the interim, the order and sentence may be suspended. I may be allowed to be on previous bail, Your Lordship. I'm already on bail.
Already on
Already
bail.
bail.
Lordship, it is 6 months.
It was a 6.
Where is that prayer? A separate IA is not required, Ms. Begum?
Lordship, he is not praying for fresh bail, Lordship. He is for previous bail.
He is already on bail.
Already on bail, Lordship.
All right.
Yes.
Munmun. This is an application under section 397 read with section 401 and 482 of CRPC 1973 assailing the impugned judgment and order dated 15/2/2024 passed by the Court of Additional Session Judge number 2 Nagaon, Assam in criminal case number 63 of 2019 whereby the conviction was upheld. Stop. Issue notice. Stop. MS.A. Begum.
Lordship,
MS.A.
his order is on 56, page number 100, that he will have to surrender on 14/3/2024. Till then only.
1 second. MS.A. Begum, learned APP, accepts notice on behalf of respondent number 1. Steps by registered court AD in respect of respondent number 2 within a period of 2 days. Extra copies in the course of the day. Stop. Yes, Ms. Begum, page.
Page number 100, Lordship. Para 56. The convicted appellant so and so shall surrender before the learned CGM Nagaon on 14/3/2024 during the court hours to undergo the sentence imposed upon him. Till then, he is allowed to remain on previous.
This is already there.
It is till then only. The bail will be extended till then only.
Till then means there is already there in
It is
page
there,
56. Then no orders required. He will appear before the
Court
CGM, and CGM shall consider.
Consider that.
Lordship, till the disposal of this, because Lordship, on 14.3 I am supposed to surrender.
Yes.
To the sentence.
You go on 14.3, surrender, and the CGM, court of CGM will consider your case
As per law.
in accordance with law. I don't think.
With your permission, my lord, we are in revision now, my lord. This court, my lord, will see whether this order of sentence is correct or not. Now, my lord, generally what happens, my lord, when the revision is there, my lord, notice is issued. This court extends the bail, my lord, allows the petitioner to remain on previous bail till disposal of the revision petition. That is my prayer, my lord. Let the petitioner be on previous bail till disposal of this instant revision petition.
He was already on bail.
He is already on.
All right. In the interim, it is directed that pending disposal of this criminal revision petition, the operation of the judgment and order dated 15/2/2024, passed in Criminal Appeal number 63 of 2019, passed by the Court of Session Judge Nagaon, shall remain state, and the petitioner is allowed to remain on previous bail
Till disposal of
until further orders.
I am grateful, my lord.
Yes.
The revision petition against the maintenance order.
Maintenance.
Maintenance, my lord. Operative part, judgment is, my lord, page 41, and operative part is 50. The
How
main
much?
fact- Only 2,000, my lord. The main fact is that permanent alimony was paid in the year of 2014 out of mutual settlement.
We are issuing notice. We are not
Only notice.
giving any interim right now. No, 2,000 rupees wait. This is an application under section 397-401 of CRPC 1873, assailing the impugned order dated 25/1/2024, passed by the learned CJM Bongaigaon in connection with miscellaneous case number 21 of 2021, registered under section 125 of criminal procedure. Stop. Issued notice, returnable 2 weeks. Miss MS A. Begum accepts notice on behalf of respondent number 1. Extra copies were in the course of the day. Steps in respect of respondent number 2 by registered post AD within a period of 2 days from today. Stop. List after 2 weeks and a date to be fixed by the registrar. Interim order, the interim prayer shall be considered on the next date.
Hey, please, Your Lordship. Lordship, this is for this revision for challenging the order that is on page 35, Lordship. Jimma of the vehicle has been affected, Lordship.
Jimma.
Jimma of a auto car, Lordship. This is the present petitioner is the owner of the vehicle, Lordship.
Where is the order?
Order that is on page 35, Lordship.
Required for further investigation.
Yes, Lordship. Now, Lordship, our High Court as well as the Supreme Court has been Sundarbhai Ambala case, Lordship, has already, Lordship, decided the matter, Lordship, regarding Jimma of the vehicle, Lordship. It is that there is no purpose of lying the vehicle in the police station, Lordship.
But here the magistrate court has, the special judge court has already applied its mind.
But
Lordship will have to call for a report, Lordship, whether it is required or not.
But Lordship, section 60 says, section 60 of the NDPS Act says, Lordship, it is if it is beyond the knowledge of the owner of the vehicle that his vehicle has
Very
been.
well, we'll call for a report. This is an application under section 397-401-482 of CRPC, seeking praying setting aside and quashing of the impugned order dated 25/1/2024, passed by the learned special judge NDPS Karbi Anglong in Dilai Police Station case number 65 of 2021, corresponding to GR number 340 of 2023, registered under section 21B29 of NDPS Act 1985. Yes, what were you saying?
Lordship, it said 23, Lord.
23?
Yes, Lord.
Yes, I've said 23. 23 likhi sato. Stop. Issue notice State is only party.
Lordship, no, only report will come.
Issue notice डालेंगे. Let a report be called for
Whether
from,
the vehicle is from Lordship, which police station?
From July.
Dilai Lordship.
from Delhi police station as required with regard to the
Whether the vehicle is required for further investigation.
with regard to the status of the seized vehicle, as whether the said vehicle is required for further investigation or not. Stop. List after?
On 22, Lordship. 22
List on 22/3/2024.
Early oblique.
May I appeal?
Yes.
My lord, we have challenged the my lord impugn proceeding
Yes.
before the my lord learned trial court, my lord, that your lordship will find at page 9. My lord.
Proceedings.
Yes, proceeding.
Yes.
The 125 proceeding, my lord.
Page.
Page, my lord, 9, my lord.
Yes.
This is, my lord, 125 proceeding, my lord. Here, please.
All right. Notice at this stage. This is an application under section 482 of CRPC 1973 seeking quashing of the proceedings of MR Miscellaneous case number 96 of 2020 pending before the Subdivisional Judicial Magistrate M. Bilasipara. Stop. Issue notice, returnable 2 weeks. MSA Begum accepts notice on behalf of respondent number 1, extra copies within the course of the day. Steps by registered post in respect of respondent number 2. Steps by registered post AD within 2 days. List after 2 weeks on a date to be fixed by the registry. Yes, AB.
My lord.
305.
Item 15 may be taken up along with the item 30, your lord. Out of this time,
30 logot. 30 also you are appearing.
my lord.
In 30 CD has
Received, Lordship. CD
has received. Yes.
Federal.
Hmm?
Federal.
Yes.
30 is bail hearing, Lordship.
Yes, yes. We'll take it up now?
No, no, Lordship. Serially, Lordship.
Okay, okay. It was 30 to logot money.
Plus, yeah.
Yes, Mr. Alam.
Quashing of FIR. This is a
Where is
second
the
FIR.
where is the FIR?
FIR is page
16.
yes, Lordship, page 60. This
Yes.
is the second FIR of its nature, Lordship. Earlier FIR is culminated into final report.
Into a
Final report. As
FIR.
police after investigation found no evidence to find guilt of the
the
petitioner.
first FIR also is in similar line.
Exactly same set of allegations.
Where is that order FR?
FIR, Lordship, will find at page 26, Lordship. Starts from page 26, operative part at page 28.
MS Begum, is it the same contents, the earlier FIR?
Lordship, I'll have.
Yes, page 28.
Is throwing up 2 lakhs, and as a security, it is alleged that they mortgaged the landed property, record of the property.
I think it appears to be same.
Second.
Second.
First FIR.
First paper starts.
It appears to be same. The contents is the same allegation of 32 lakhs.
32 lakhs, Lordship. Mortgage paper.
We'll,
Lordship, we will call for the CD then, Lordship.
Along with the scanned copy of the
I'll
final
see.
report.
so till then, we'll stay this further proceedings in this FI. It looks the same.
Lordship.
This is an heard Mr. Z. Alam, Learned Counsel for the petitioner. Stop. Also
LCR
heard.
will be called.
Yes.
Lordship, LCR will be called.
Also heard MSA Begum, Learned APP for the state respondent. Stop. This is an application under section 482 of CRPC 1973 seeking quashing of FIR dated 7 to FIR is dated
Second FIR, Lordship, 7 February 2020.
FIR dated 7 to 2023, registered as Hatigao PS case number 47 of 2023 under section 406, 420, 448, 468 IPC. Stop. Next para. Mr. Alam submits that in respect of the said same in respect of the contents of this FIR, earlier also another FIR was filed, which was ultimately in which final report was submitted, which is at page page 26, annexure 4. Stop. A perusal of the aforesaid final report indicates that in respect of the same allegation, the IO has found the IO upon collecting no sufficient evidence materials against the accused person has finally submitted the final report. Stop. In view of the above, in the interim, further proceeding investigation of Hatigao PS case number 57 of 2023, registered under section 406, 420, 448, 468 IPC, shall remain state until further orders. Stop.
We will call for the FR from the police station. Report will be called for, Lordship.
Let the FR
A report from the Gwalpara.
from the from where? From
Gwalpara police. Gwalpara
from
police.
Gwalpara police station be called for through the registry.
No, Lordship.
Be called for. Stop.
Please, please.
In connection to which case?
Your Lordship,
Hatigao,
Hatigao,
In connection with Hatigao PS case number 57 2023, be placed before this court on the next date. Registry Nokobaito, ATP Digo. Date dilu na? After 2 weeks. You want a date, Ms. Begum?
Lordship, after Lordship, it will be on 27th of March.
27th of March. You do one thing, interim
Can it
order
be
till then.
Lordship on 3rd of April, because we have
3rd April and interim order is till then.
Lordship.
deeply of that.
$15 to piece off. Yes, Mr. Chaudhary? LCR was called?
Yes, my lord. LCR was
Yes.
called for.
Not received?
Not received, Lord.
Await LCR. Stop. LCR is going to be from?
To registry from
Oh, LCR has come.
Special judgment.
LCR has come.
No, Lordship, it doesn't show in the first list.
What is?
I don't know.
LCR
Can I just have a look?
Only record. Huh?
ऐसे नहीं. हाँ?
I think it is there. Anyway, you examine it. We will have it next week.
Lordship.
In item number 16, you say
Can I
that.
just go through my life? I'll just go through the records for a once.
Item 62.
Release this matter after next week. On next week, any particular date?
My lord,
We are not-
it will be on the 22nd of March.
LCR is there.
22,
March.
22/3/2024.
And
Yes, next. In the meantime, Mr. Chaudhary, you have a look at it.
I'll have
If
a
there is any changes need to be done in the order, I will do it.
And-
All right. Yes.
date is your lordship.
Lordship, in this case, Lordship, may I pray, Lordship, let this matter be listed on first week of April.
As
because,
prayed
Lordship,
for by Mr. B. Chaudhary, list this matter.
Lordship, matter related to maintenance, Lordship.
When do you want it?
First week of April, Lordship.
One more small submission, my lord. Only 5,000 rupees maintenance advance is granted, my lord. 8,000 is wife and 1,000 with minor side. From the date of filing of the petition, my lord, till date, my lord, nothing was paid, my lord.
All right, we will have it on 1st April and we'll hear it on that. List for 1/4/20.
Highly obliged.
Yes. Yes. Quashing of what?
My lord, we have challenged an impugned order of cognizance that has been taken in the NIA proceedings matter. My lord, item number 18 and 19 both are connected matters, my lord.
Okay.
18 and 19 pending before the same court at Hailagandi. My lord, in this case,
Respondent is appeared.
I am for the respondent number 2, your my lord.
2. All right. Yes.
My lord, in this case, my lord, here the petitioner is item number 18. The secretary of educational trust, name of Cambridge Educational Trust, and for the construction of his third school, he was looking for some suitable investor, or my lord, form of some loan. So out of common acquaintance, new respondent number 2 appeared. Out of common acquaintance, he extended his help so that he can invest some money. So he in the form of loan. About 50 lakhs.
50 lakhs?
Yes, around 50 lakhs. So while he took the loan, some as a security, my lord, he deposited numbers of check that said person, along with some money receipts that said, again as security against that said loan. Now thereafter, my lord, while those checks were in the custody, let's say respondent number 2, my lord, the respondent number 1, my lord, of course, deceitfully took away those checks and, my lord, deposited. When we came to know when the checks were being deceitfully being taken, we registered an FIR at Jalukbari PS.
The loan was taken by
respondent number 2.
By respondent number 2.
We took it from respondent number 2. He
you are
for the construction of our school. Since we are running a educational trust.
So, loan was given by whom?
Respondent number 2.
Respondent number 2 gave loan to respondent number 1.
No.
To you.
To the petition.
And against that you had given 2 checks as security.
6 numbers of checks.
6 numbers of checks as security. Which respondent number 1 forcefully took it out from respondent number 2 and deposited it in the bank.
Yes.
Then
and at that point of time, my lord, one just checks were returned unpaid. They instituted a case at Hailagandi.
138.
Yes, under 138 proceedings, they instituted, and accordingly summons were being served.
That is the proceeding you are seeking for quashing.
Quashing as well as the impugned order of cognizance. Because, my lord, if lordship comes to annexure number 3, well, since I have previously stated that these both matters are connected. Matter number 18.
Page?
Annexure 3, my lord.
Page 41.
Page 41. This is the statement on affidavit under section 200 CRPC, my lord. My lord, while coming to the mark 1, if lordship turns to page number 42, running page 42,
yes.
Mark 1 is the Xerox copy of the checks, byte number 02732.
Yes.
This 2 number of checks has been used in, this same check has been used in 2 cases, my lord. That is it. If lordship comes to the second...
the Mark 1 and Mark 2 or only Mark 1?
Mark 1, my lord.
Mark 1, this check number is used in relation in 2 cases.
2 cases.
Yes.
It's apparent on record.
Yes.
And in item number 19, my lord, the same petitioner, she is the trustee, wife of the petitioner.
Yes.
Here also, if lordship comes to
item 19 to Deboning. I think this will take some time. We'll fix it for hearing, then we'll admit and fix it for hearing.
Yes. My lord, till then, my lord, interim may be...
No, not the interim. So you ought to have asked when you are moving this petition. Every day you can't be trying your luck on an interim. The matter is fixed for admission today. In item 18 and 19, heard
for the moment,
your name?
P. Das,
heard Mr. P. Das, learned counsel for the petitioner. Stop. Also heard
M.J. Kadir.
Mr. M.J. Kadir, learned counsel appearing for respondent number 1. and Mr. T. Chetri, learned counsel, appearing for respondent number 2. Stop. There appears arguable point in the criminal petition. Stop. Admit. No, this is already admitted, isn't it? List these matters for hearing. Item number 1819. When do you want it hearing? We'll give you a short date if you want.
April 1st.
List these matters for hearing in the month of April on a date to be fixed by the registry.
Interim shall be considered because, my lord,
No,
since
no.
it is a
Yes,
we are
next.
challenging the order of
All
cognizance.
right.
My lord, bill number 20 and 21 is with the same, is with regard to juvenile why?
Determination of age.
No, my lord, here what happened was that two sons of the petitioner, two sons of the petitioner died on the same. Thereafter, X and Y was arrested along with one adult. They remained.
This is a POXO matter. No.
What happened was the X and Y remained as, my lord, adult. Thereafter, their father, the father of X and Y, brought a certificate stating that they are juvenile. Preliminary inquiry was done. Petitioner was busy in funeral and all. When he came to know, with the help of the SP Lakhimpur, SP Arunachal Pradesh, along with the OC of the Arunachal Pradesh, inquiry was conducted. They found out that any certificates were made out in between. The original of X certificate was not a juvenile. Y also was not a juvenile. What we did was that the CISM who has passed the order claiming their juvenility, we have challenged. The learned CISM said that since I have already declared juvenile and since the matter has gone to the principal magistrate, let the principal magistrate do an inquiry. Inquiry was initiated. IO report was called for, in which the report reflected that yes, many certificates were procured. What the learned principal magistrate did was, inquiry was going on, dates were going on, in between all of a sudden an order was passed. I cannot review my own order. Whereas that order that she have quoted, the learned court has quoted, was the order of the additional season, not the order of the learned principal magistrate. So we came for a quashing here with regard to...
Mr. Chaudhary, you are for the government. These are for admission.
My lord, my lord, here what happened was that, here the stay, my lord.
We'll admit and fix it for hearing.
My lord, can it be...
You are already having an interim order in your favor.
Two interim orders, certificate.
Yes.
Because, my lord, here,
all right.
we do not want to delay the trial because delaying of the trial...
Very well. Let us admit and we'll post it for hearing you in the month of April. I heard your name.
Lordship, I am appearing on behalf of Mr. K. Borua. S.C. Borua.
Heard MSSG Borua, learned counsel for the petitioner. Stop. Also heard Mr. NNB Chaudhary, learned additional advocate general, learned additional advocate general Arunachal Pradesh, and
Miss P. Bora,
Miss
appearing on
P.
behalf of Mr. K. Borua.
Miss P. Bora on behalf of Mr.
K. Borua.
K. Borua, learned counsel for respondent numbers
8.
For respondent number 8. Stop. And your name? And Miss M.S.R. Gogoi, learned counsel for respondent numbers 1, 2, and 3.
I am 4, 5, 6.
And AG, additional AG 4, 5, 6, and 7. Stop. Admit. List this, since respondents are already represented, no formal notice required. Stop. List this matter for hearing in the month of April on a date to be fixed by the registry. Interim orders passed earlier shall continue till then.
On 2nd of April.
2nd April, I think, will be difficult. After Bihu, otherwise we'll give you a date after Bihu.
23rd, Milo, 23rd April.
Because 20, dialogue 23, hearing day.
The Tuesday, Milo. We'll take.
All right, 23, 4, 2024.
21 also same.
All right.
Oblige. Milo, interim orders.
I have said.
Mass oblige, Milo.
Complaint case 420, 415.
My lord, complaint filed by the elder sister, my lord.
Scan copy LCR was called in this matter.
It is already with the record, my complaint filed by the elder sister, my lord, alleging, my lord, misappropriation of the inheritance property, man, against the younger sister and her husband, man. Against which,
Respondent, anyone appearing?
Lordship, passport for timing. Senior counsel is another.
Not time being, then Monday.
Monday, my lord, it will not be possible for me, my lord. Then, my lord, let it come in April, my lord.
All right. As prayed for, list this matter on April 8. 24/4/2024.
My lord.
Both parties. Huh? Yes, Mr. Tiwari?
My lord, hearing this case, my lord, I have been,
Petitioner, anyone appearing?
my lord, I was,
Petitioner? None appears for the petitioner when the matter is called. List this matter in the month of April.
my lord, next week, because my lord, 145 proceeding was there, my lord.
Acha,
my lord,
list this matter next week
because the respondent has already
on a
expired,
date to
my
be
lord.
fixed by the registrar.
It's get abated, my lord. I'm obliged, your lordship.
Mr. Bora? Criminal petition.
Yes, my lord, that is the case, my lord. Lordship has occasion to go by the
Case diary, I think, Mr. Das?
yes.
Is there, but no, actually no progress was made because but stay order is there. No.
I think
And
at
the
that day
government
also
and the
we
Home
were
Department, yes.
wondering why case diary is required, if I recollect. This is page 17 is the FIR which you are seeking quashing.
First, from the bare reading of the FIR, my lord, our contention is that no case under section 498 has been made out. No prima facie.
Section 498A.
498. The equality has been defined very well, ma'am.
Our allegation is that that the accused threatened her not to use his name,
Yes.
and that is
the-
basically threatening, right?
Basically.
Only threatening, isn't it? Nothing else. And he was already married.
I am
This
already
fact was
married.
concealed.
Yes.
That, of course, it will not make a difference. 498. Here, was there a marriage? There was no marriage.
No marriage. Yes, claim, my lord.
So,
But
in order to
and the-
attract 498A, there has to be a
Marriage and
marriage.
she claimed to be the second wife. Second wife doesn't have that, my lord. 498A cannot be a wife, my lord, in the definition of the wife of section 498.
Because that is why you say 498A is not attracted.
Not attractive, and apart from, my lord, the
Allegation also
allegation
are
prima facie, my lord, does not make out any
Yes.
case for registering it under
498A.
A, my lord.
If 498 goes, then 494 and 506.
Non-cognizable offense, my lord.
No, but this is a quashing, isn't it?
Yes. They could not have registered, my lord, because of the. First of all, there has to be prima facie material under section 498A.
498A, this court prima facie is with you, unless Mr. Das. Mr. Das, there is.
But I have no hesitation to submit that there is no ingredients of 498.
Correct. 498, let us.
From plain reading of the FIR.
Absolutely. Now let us come to 494.
My lord.
This is important. 494 and 506.
506, my lord, lordship can non-cog FIR, my lord. The police cannot register it without the permission of the court, my lord. 506.
No, let us first see 494. So there has to be a marriage also in 494.
Yes.
Mr. Das?
My lord?
In section 494,
Yes.
Oh, it says had got married with me.
Or second marriage of the person having living spouse.
Mr. Bora, it would be difficult for us to quash in respect of 494 because whatever be correct or not correct.
No, because it's a non-cog offence. What you kindly see, they cannot register it. It's a non-cognizable offence. Statutory bar itself.
Non-cognizable.
Statutory bar is there, my.
Which section?
494.
No, where is the statutory bar?
494, my lord, the non-cognizable offence.
Is that I have seen?
One, Lordship will say, now Lordship kindly see CRPC, my.
One?
I'll come, my. One. And there is a non-cog offence, my lord. First of all, Lordship E 134 onward.
1?
E
134?
154.
150 of CRPC?
Yes. 154 onward.
Yes.
Every information relating commission offence in orally. So there has to be a cognizable offence. Then 155 Lordship fine. No police officer shall investigate a non-cognizable
Without
offence.
the order of a magistrate.
Yes. Having power to try such case and commit the case for the trial.
So here, magistrate's order is not there.
No. Without the registers, they have stateway, they have registered it.
So that is a procedural irregularity.
Yes, so that is a full bar, they cannot register it. That's it. So there is a Juvenility case is there, my lord. Juvenile has if category enumerated all the categories, that is the one of the category, my lord, as far as the Juvenility is concerned. When the FIR can be quashed.
Please point out that part from Bhajan Lal. You're carrying it?
No, my lord, I have not carried it, my lord. But
Only for that part.
Yes.
Otherwise, Bhajan Lal's parameters are well known.
Yes. That part is there. They are all in that non-cognizable offence. There cannot be any investigation without the prior
See,
permission.
because you are right that there has been a procedural irregularity, maybe because it was combined with 498A, that is how cognizance was, FI probably was registered. Now, if we remove 498A,
yes,
then it is left with 494
and 506.
and 506. And we will direct the investigation officer to re-register it in accordance with law. But only on that ground, why should we stall the entire criminal proceeding? Because on the face of it,
yes,
ingredients of 494 is...
Now, Lordship kindly say there is one more bar. Lordship kindly say.
Yes.
Lordship kindly see 198.
198 of?
CRPC.
$198. Yes. $198, yes.
19.
Prosecution for offences against marriage?
Yes.
What do you want to show from here?
So, my lord, the As far as these petitions are concerned, ma'am, we now the option for the
Are you having any stay order in this case? You are enjoying it.
interim. So the 498 definitely there is no case. So for the rest of the them, open for the police. It will be open for the them.
Correct.
If they want to go.
If they want to proceed, they will
They
proceed
can
in accordance with
in
law.
accordance with law.
This is what this court is saying.
That much.
To that, if you are all right, then we can dispose it with that direction.
That only that part.
All right. Item number
As an
6.
interim order vacated.
Heard Mr. A.M. Bora, learned senior counsel, assisted by Mr. B.K. Vaidya, learned counsel for the petitioners. Top. Also heard Mr. D. Das, learned APP for the state respondent. No private party, right?
Private not appeared, madam. Name has been shown twice, madam. On all previous two occasions, they have not appeared also.
Their name has been shown. Yes. Though the name of the respondent number 2's counsel has been reflected in the cause list, none appears when the matter has been called. Stop. What are these case laws, Mr. Bora?
My lord, one is the ingredient of 498A, and second is that the second locus of the second wife regarding the 490.
Okay. This is an application under section 482 read with section 401 of CRPC for quashing of the FIR dated so and so in connection with Dispur police station case number 2189 of 2022. FIR dated 29/9/2022. Correct? Stop. The facts of the case is that on 28/9/2022, the informant respondent number 2 lodged an FIR before the Dispur police station alleging inter alia that the present petitioner had got married with her in the year 2008 by concealing the actual fact that he had already been married with another lady, and that the entire scenery has come into the picture after spending 2.5 years while she had conceived. Stop. She stated it is further alleged that despite It is further alleged that the petitioner suddenly stopped providing food and shelter to her and her child. Stop. It is further alleged that in the last few months the behavior of the petitioner has changed and the petitioner compelled her to withdraw the name of the father whereby written to withdraw the name of the petitioner from all the documents, certificates, etc. Stop. It is further alleged that the petitioner frequently threatened her and her family members. Stop. Mr. A.M. Bora, learned counsel for the senior counsel for the petitioner, submits that no case of section 498A is made out in the face of the averments, the FIR. Stop. He further submits that there is no material of any cruelty committed by the petitioner on the informant as defined under section 498A, and as such section 498A is not attracted in the instant case. Stop. He further submits that 498A of IPC is only attracted against the husband or a relative of the husband, and in the instant case, the petitioner by no means is the husband of the informant. Stop. He further submits that the provisions of 494 IPC are also not attracted against the petitioner, inasmuch as he has not married the informant or any other person and has only ever married his wife. He further submits that the provisions of Section 506 IPC are also not attracted against the petitioner, inasmuch as he has never criminally intimidated the informant. Stop. Mr. D. Das, learned APP, on the other hand, submits that on the other hand, fairly submits that though the ingredients of Section 498 capital A prima facie are not attracted in the face of the averments made in the FIR, comma, the ingredients of Section 494 cannot be set,
and 506.
And 506 are in the face of the averments made in the FIR. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. Section 498 capital A IPC is extracted herein below for ready reference. Stop. Quote unquote kore diba 498 capital A. A perusal of the aforesaid provision indicates that it is against the husband or his family members against whom, if cruelty is proved, comma, the offense is brought home. Stop. Reference is made to the decision of the Apex Court in the case of Kantilal Martazai Pandor versus State of Gujarat, reported in 2013, Volume 8, SSC 781. Paragraph 13, 14, and 15 of the aforesaid judgment is reproduced herein for ready reference. We are ready to. What is the second case, Mr. Bora? Second case also is in connection of ingredients of 498A only.
Locus, my lord.
Locus?
You Suveta, my lord.
Yes.
Yes, it
That
is
is
locus,
on
my lord.
locus.
Yes, my lord.
What do you
also does both.
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 Then you also say reference is also made to the decision of the Apex Court in U. Suveta versus State, reported in 2009, Volume 6, SSC 757. Paragraph
7, my lord. 7.
7 to
7,
7, 9.
7, 8, 9.
7, 8, 9. I think that's all. 10 may not be required because here it is not the relative.
Yes, ma'am.
This will not be
Relation.
relevant.
9 is the one.
9 is the main. In fact, you may just, okay. 7, 8, 9 of the aforesaid decision is also reproduced herein for readiness. Stop. In the present case, the petitioner is already married to another person, and as such, the ingredients of section 498A prima facie is not made out. Stop. In view of the aforesaid,
Regarding, my lord, that Bhajanlal, my lord, you also mentioned in the paragraph.
I have seen one of your grounds.
Yes, yes. 1992 supplementary 1 SFT. My lord, it will be in the judgment, lordship will find it, paragraph.
I have seen
8.1.
But do you need that to be quoted? Because
regarding the other two, my lord.
other
It is
two,
non-cognizable offense.
correct, but you have already agreed, so we will dispose it of in that
On
direction.
that indication that as a non-cognizant offense, that the investigation has to follow as per the.
If it
provisions
is
of-
non-cog, they will do in accordance with law. We will simply say that,
that
Mr.
much.
Bora. Then you say, accordingly, the FIR, and then you say that it appears that further proceedings in connection with the FIR dated 29/9/2022 under section 498A is not justified. Stop. As such, this court is of the considered view that this writ petition can be disposed of. This criminal petition can be disposed of with the direction that the FIR dated 29/9/2022 in connection with Dispur Police Station case number 2189/2022 registered under section 498A be set aside, and it is open for the police authorities to proceed further if they desire so in accordance with law. So, that should be sufficient.
In respect of other two offences.
I am not mentioning anything. Proceed further if they so desire. You need to mention in respect of the other two offences mentioned in the in respect of the other two offences, i.e. 494 and 506 of IP, if they desire so, in accordance with law. So, with the aforesaid direction and observation, this criminal petition stands disposed of. That should be sufficient, Mr. Bora.
Only one remark regarding my submission, my lord.
Yes.
That the non-cog offense. That only.
On top where we are saying Mr. M. Bora submission, that he further submits that the section section 494 and 506 are non-cognizable offences and hence cannot be registered without the prior permission of the magistrate in terms of section 155 of the Criminal Procedure Code. 155 within bracket 2 of the Criminal Procedure Code.
Obliged.
Interim order stands vacated.
Interim orders shall stand vacated.
May I please your lordship?
Connected.
First, item 24.
Yes.
My lord, FIR, page number 9 to 11. I am behind the bar since 65 days.
Page?
FIR page 9 to 11.
Even number?
24.
24.
Yes.
My lord, actually this was an agitation against a newly amended law.
How many days?
65 days, my lord. My name is not in the FIR.
Yes.
It was an agitation against a new amended law, that is hit and run case. made by the drivers. A local people joined.
The police officer was assaulted.
Yes.
Not assault, there is no injury report. 307 is not attracted, my lord. Not a single piece of
Injury report there.
307 injury is not.
Not, my lord. There was an altercation.
Injury is not necessary for 307.
There was an altercation.
No, but
between
is
the
this
picketers.
petitioner, the petitioner is named in the FIR? No.
No,
There was a mob.
He's one of the as many as 22 persons name, my lord.
22 persons.
But my name is not there.
Yes. What does the investigation show, Mr. Das?
My lord,
Any role attributed to the petitioner?
Well, there are video recording. From video recording, he was identified.
I was standing in front of my
He
shop.
was present.
In front of my shop.
Let him complete, Mr. He.
Take your seat. Let me find out. We'll come back to you if needed.
Video recording. Other people were. Since this is a case of mob lynching, the police officer went to control the mob lynching.
His uniforms were torn and.
My lord. So, my lord, length of detention, your lordship may consider because he
No,
is
that is one thing. Otherwise,
but
from
otherwise, my lord,
you see, from the materials,
photographs are there, my lord.
from the materials, what this court has understood is that he is present,
He was.
but no overt act or no role as such is.
And his statements are also recorded, my lord.
So any of the co-accused have said
No,
that
so
he
many- no, other-
is present or he is involved.
My lord,
Anyone
named
has
accused. Most of the named accused are, my lord, absconding.
absconded.
They
No, but he is not a named accused.
He is not named accused.
He is not named
But
accused.
he was present.
So merely he is present only for that 65
Only,
days.
my lord, length of detention, your lordship. On that ground, my lord, 64 days. And
And what about item 66?
64.
64.
He since behind the bar 47 days.
40?
47. My name is also not in the FIR.
All right, we'll see that when we go there. In item number 24 first. Okay. Heard Mr. A.T.M. Hussain, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondent. Stop. This is an application under section 439 of CRPC for granting regular bail to the accused petitioner i.e. Jamil Ahmed, who was arrested on 8/1/2024 in connection with Bajirchera Police Station case number 6/2024, registered under section 147, 148, 149, 152, 341, 353, 307, 332, 392, 436, 511 of the IPC. Stop. The facts of the case is that on 5/1/2024, upon receiving an information that approximately 200 numbers of people has unlawfully assembled at Kathortoli market, the informant along with staff proceeded to the spot. Stop. After arriving at the spot about 10:15 a.m., the informant asked the people who were blocking the road clear the road, as the road is busy road. But suddenly, the FIR named accused persons, along with few others, dragged the informant inside the mob with intentions to kill him. Stop. It is further alleged that they also tried to tear his uniform, and one accused person, i.e. Abdul Manan, snatched his nameplate from his wearing uniform. Stop. It is further alleged that with the help of the informant's staff, somehow he managed to escape from the mob and came to the, what is WP? Kathardoli WP? What
Watch
does
post. Watch post.
to the watch post. Stop. Mr. ATM Hussain, learned counsel for the petitioner, submits that the petitioner is not named in the FIR. Stop. He further submits that the petitioner is not a member of the unlawful assembly and he was merely standing
in front of his shop,
and on that basis he was suspected to be a part of the unlawful assembly. Stop. Mr. D. Das, on the other hand, he further submits that the petitioner has been languishing in jail since last 65 days. Stop. Now you see, Mr. D. Das, that APP strongly, on the other hand, strongly opposes the prayer for bail. Stop. He submits that there are photographs collected by the investigating officer which indicates that the petitioner was present in the spot. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. From the materials available on record, it appears that the petitioner was present in the spot. Stop. However, there are no materials as of now indicating that the petitioner had participated in the alleged incident. Stop. Investigation appears to have progressed substantially. Stop. The statements of the petitioner has already been recorded. Stop. Considering the length of detention, this court is of the considered view that further detention is not justified. Stop. Accordingly, the petitioner is allowed to go on bail. The petitioner named above is allowed to go on bail in connection with the above noted case with a bail bond of rupees 30,000 with satisfaction of learned CJM Karimganj. Those three conditions, bail petition disposed of.
Next, my lord,
64. One second. 64 to 64 will be also same only thing.
Same FIR.
He is
46 days.
My name is not in the FIR.
Same, everything will be same.
Almost same.
Almost.
He says he went for a haircut.
I was not present there.
So here you say where in his submission submits that you had gone for a haircut.
Yes, ma'am.
To where?
To this market.
That the petitioner had gone for a haircut to the saloon which is located at the spot.
In the Kataltoli market.
Spot at the market. Stop. It
But
will
he
be
says
the above submission.
having seen the move, he participated in the move.
Just observing.
46 days. Yet
47
languishing
days.
47 days. See, James, same.
Animal.
Everything else remains. Baki first.
Will you oblige, my lord?
Disposed of. This is 66. Dispose of. Sorry.
May I please, Your Lordship?
Right.
499 application, Lordship.
Yes.
Case
CD?
behind number for 30 days. CD was called for, Lordship. CD is
So the CD available?
Yes, CD available. You know.
How many days?
30 days, and he was last interrogated on 12/2/24.
12
to 24.
to 24.
It is on the date of arrest itself.
Probably further detention may not be required. Heard Mr. K.K. Hendick, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondent. Stop. This is an application under section 439 of CRPC seeking granting regular bail to the accused person, who, i.e. Atikur Rahman, who was arrested on 11/2/2024 in connection with Dispur PS case number 42 of 2024, registered under section 120B, 420, 468, 471, 409 of IPC. Stop. very long FIR.
Long FIR.
That is landscape, my lord. Landscape. He engaged.
The case of the prosecution is that, OP, this you will get in paragraph, page. Stop. Mr. K.K. Handick submits that the accused person is totally innocent and he has not committed the offence alleged and is no way involved with the alleged offence. And he is not a FIR named person.
He is not a
And he is not an FIR named person. Stop. He further submits that the petitioner has been languishing in jail for the last 30 days. Stop. Next para. Mr. D. Das, learned APP, on the other hand, strongly opposes the prayer for bail. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. Considering the... Stop. Then you say that it appears from the materials available on record that the petitioner was last interrogated on 12/2/2024. Stop. It further appears that the investigation has substantially progressed. Stop. Considering the length of detention, this court is of the considered view that further detention of the petitioner is not justified. Stop. Accordingly, petitioner named above is allowed to go on bail. In connection with the aforenoted case. With a bail bond of rupees
50,000.
50,000 of one surety of like nature, CGM Kamrup, and the three conditions. With the aforesaid observation, bail application stands disposed of. Yes. 307, 302.
Yes, my lord. 307, 302, 826. But in the case diary, my lord, inquest report, post-mortem report, my lord, nothing is available in the.
Because, my lord, there is no injury. The person died in heart attack.
Died in heart attack?
Yes, my lord. Because what happened, my lord?
Only post-mortem report will confirm that, but
it is not there.
Post-mortem report is available.
How many days, Dr. Ahmed?
61 days.
Mr. Ahmed? Huh?
61 days.
61 days.
My statement has already been recorded. My statement also recorded.
Sorry, your statement has been recorded. Yes. When was he last interrogated, Mr. Bhattakur?
He is in judicial custody. Definitely, his statement will be available in the case diary.
But case diary is not here today.
The case diary is available, but post-mortem report regarding the cause of death.
No, his statement is available.
Yeah, his statement is available. His statement recorded on 10/1/24.
10/1/24. 24.
11/1/24, mother.
10/11.
11/1.
On the day of his arrest.
11/1/24. Statement recorded. That was the day interrogated, correct?
Yes.
And since then, he was not further interrogated. Ejahar is at page?
Page, my lord, 9. Translated copy at page 9.
All right then. Considering the length of detention, here for the informant. Heard Mr. J. Ahmed, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned APP for the state respondent, and Mr. G. Chamua, learned counsel for the informant. Stop. This is an application under section 439 of the CRPC for granting bail to the petitioner, i.e. Hassan Ali, who was arrested on 11/1/2024 in connection with Mirichar PS case number 3 of 2024, registered under sections 326, 307, 302 IPC. Stop. The fact of the case of the prosecution is that one Mofidul Islam lodged an FIR alleging inter alia that the informant brought ravels sent to build house on his land and raised a hut and raised a small hut to keep some persons for patrolling, just to avoiding for stealing of those items. Stop. But on 10/1/2024, at about 3:30 am, the accused person started to beating on the wall of his house. Stop. After seeing that the informant called his parents and after reaching of his parents, the accused person attempted to attack his father and grounded him by pushing his ankle. Stop. Thereafter, the accused person attacked the informant with kukri and he sustained cut injury on his left hand. Stop. Accordingly, a case has been registered. Stop. Mr. J. Ahmed, Learned Counsel for the petitioner, submits that the allegations are completely baseless and
We also lodge FIR.
Huh?
We also file FIR on
You file an FIR stating what?
that they forcefully taken away their house.
And that the informant has forcefully taken the petitioner to their house,
and roped.
to which effect a case being Merachar Police Station case number 04/2024 under section 341, 325, 3707, 120B, 354B IPC has been registered. Now, Mr. P. Thakur, Learned APP for the state respondent, strongly opposes the prayer for bail. On the other hand, then I have perused the. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that the petitioner was arrested on 11/1/2024 and on the date of arrest the petitioner was interrogated. Stop. However, the petitioner has not been interrogated thereafter. Stop. Considering the length of detention, this court is of the considered view that further detention of the petitioner may not be required. Stop. Accordingly, the petitioner above named is allowed to go on bail in connection with the above noted case on a bail bond of rupees 30,000 with one surety of like amount to the satisfaction of SDGM Abhayapuri, not Salmara Abhayapuri. Please say it correctly, otherwise it will be difficult. SDGM, right? You got it? 3 conditions.
Only one ground, only one condition added.
Yes.
To threaten the.
In the 3 grounds, 1 grounds not to threaten. Okay.
My name may be recorded.
Yes, it is recorded.
SDGM M, not Salmara Abhayapuri.
SDJM
M.
M. Within bracket M.
Within bracket M.
Not Salmara
Abhayapuri.
Disposed of. Yes. Mr. Mahajan?
My lord, with all respect, my lord. My lord, with all respect, my lord, so far as the FIR is concerned, possibly no case of 376. Promising to marry and not marrying, there are 2 years gap in between, my lord. And in our application, we have categorically stated, my lord, parleys are on, my lord. Parleys are on, my lord. Might be settled also, my lord. I do not know what is there.
Well, in this case, charge sheet has been submitted.
In this given situation, a charge sheeted case, when, my lord, during investigation, case diary is sought for, my lord, and charge sheet is submitted. Even in sessions tribal offences, possibly, my lord, the Indian criminal justice very system, the law, my friend knows. Can I please come to authority, my lord, wherein, my lord, if prima facie or ex facie on perusal of the FIR, my lord, nothing is made out, but possibly bail may still be granted, my lord. Can I place the authority?
Yes.
This is, my lord, my lord, Biplop does, this relates to, my lord, with all respect, my lord, POSCO Act, my lord. There also it has been granted. So
your charge sheet has been submitted?
Yes, my lord. Can I read paragraph 5, my lord? On the
Para?
other hand, Mr. Gogoi submits, like in the present case, my lord, that though the case...
This is item 36?
36.
Item 36. Heard Mr. L.R. Majumdar, learned counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, learned APP for the state respondent. Stop. This is an application under section 438 CRPC seeking granting pre-arrest bail to the petitioners, i.e. number 1, Mithun Ravidas and number 2, Uttam Ravidas, who are apprehending arrest in connection with Lakhipur PS case number 319/2023, corresponding GR case number 406/2023, registered under section 147, 148, 149, 341, 333, 307, 353 of IPC. Stop. The case of the prosecution is that on 28/11/2023, an FIR was lodged before the jurisdictional police station against the accused persons by one Fakiruddin, ASI, Lakhipur Police Station, alleging inter alia that on 28/11/2023, an information was received by the officer in charge from a reliable source that a gambling is going on illegally at Binakandi Grant near Kali Mandir. Stop. Accordingly, they proceeded to the spot, and when they reached, the gamblers and also about 20 to 25 persons attacked them with sharp and dangerous weapons, etc., to deter their duties, and badly assaulted his accompanied staff UBC 305, Iqbal Hussain, and ABC 441 Gohin Das. Stop. Mr. L.R. Majumdar, learned counsel for the petitioner, submits that they are not involved with the case and was falsely implicated in this case. Stop. He further submits that on that date a festive season was going on, which was organized, and some people of the locality had organized an orchestra program on 28/11/2023. Stop. He further submits that the petitioners had gone to see the said program, and while they were assembled there, they saw that there was a scuffle going on between some people and police staff. Stop. He further submits that they have been named in the FIR purely on the basis of suspicion, only because they were present there. Stop. Mr. P. Borthakur, learned APP, on the other hand, strongly opposes the prayer for bail. Stop. He further submits on the basis of the materials available on record that though the injury report of the injured are not available in the case diary, a photograph is there which indicates that one of the injured person sustained injury in the head. Stop. Consider next paragraph. I've heard the submissions made at the bar and have perused the materials available on record. Stop. There is nothing directly against them.
So there are altogether 20-25%.
But nothing direct against them, isn't it, at this stage?
Yes, direct material against.
It appears that there is no material directly attributing to the petitioners available at this stage. Stop.
However, in the FIR, my lord, their name is
correct. Considering the entire aspect of the matter, this court is of the considered view that custodial interrogation of the petitioners may not be required for the ongoing investigation. Stop. Yes, yes.
Till now they have not appeared before the
I know.
so let them appear.
That is what we'll direct. Where you had OP, where you had said Mr. Petitioner submissions, at the end of the submission says, he further submits that the petitioners are ready and willing to cooperate with the investigation. Okay? Then you say, accordingly, it is provided that the petitioners named above, in the event of arrest, shall be released on pre-arrest, in the event of arrest in connection with the above noted case, shall be released on pre-arrest bail on furnishing of a bail bond of rupees 15,000 each, 15,000 each, to the satisfaction of the arresting authority, subject to the following conditions, of course. Stop. Then just appear within 7 days and inducement. With the aforesaid direction and observation, this anticipatory bail application stands allowed and disposed of.
Online.
37.
Yes. Is diary available, Ms. Begum? Yes.
Name are not in that. The same the day before yesterday on 11 March, we could grant bail on other co-equal. 11 March, day before.
Just B. Was behind the B.
There, is it because of the length of detention?
Lordship, they are behind the bar, Lordship.
What is this case?
This is, Lordship, they are absconding, Lordship. Mustaq Ahmed Laskar. He is the prime accused, Lordship. They did the plan of burning the shop of...
Oh, that burning shop.
Yes, Lordship.
So their name are not in the FLO.
They are the prime accused. They have set the meeting and they have... the plan was executed by Kausar Hussain Majumdar to Rajiv Paul and complainant Mustaq, Lordship, Mustaq Ahmed Laskar is the prime accused in committing the crime.
When I refer to your argument, you just point that out, all right? Sorry, this is an AB. We'll see when you come again. Because the materials are there against you. Your name?
M.H. Soikia, Lordship.
N.H. Majar Bhuya?
M.H. Soikia.
M.H. Soikia. Heard Mr. M.H. Soikia, Learned Counsel for the petitioner. Stop. Also heard M.S. A. Begum, Learned APP for the state respondent. Stop. This is an application under section 438 of CRPC seeking for pre-arrest bail to the petitioners I, 1, 2, 3, 4 and 5. They all 5 are prime accused.
Lordship, during investigation, absconding accused Mustaq Ahmed along with the other co-accused involved who are absconding since after committing the crime.
Stop. Paying for pre-arrest bail, the 5 accused names you who are apprehending arrest in connection with Katlichera Police Station case number 183/2023 registered under section 29450643634 IPC. Stop. The case of the prosecution is that on 13/10/2023, the FIR named accused person had threatened the informant while he was coming to his shop, and when the informant protested, they threatened to kill him. Stop. It is further alleged that thereafter on 15/10/2023 at about 1:30 am, the informant was informed by the local people that his shop was set on fire. Stop. Accordingly, the FIR was registered. Stop. Now these 5 people are named in the FIR?
While interrogation, Lordship,
Their names had come. Okay. Mr. M.H. Soikia, learned counsel for the petitioner, submits that the petitioners are not named in the FIR and the petitioners were not present on the date of the incident. Correct?
Other matter. Lordship, may kindly peruse para 4 of my brief.
Yes.
There is another matter involved, Lordship. The petition, the government of India sanctioned a model degree college in Hailakani. Site selection committee of the government selected nearby Boldavoli Village and Sultan Sera Garden, the site for establishment of the said college. But the local MLA, with a few development of his personal land at Manipur Garden area, attempted to.
He further submits that the police authorities are dragging the name of the petitioner in the present FIR as the petitioner is. You filed the PIL?
Lordship.
As the petitioner had filed two public interest litigation before the Guwahati High Court. Yes. Stop. Next question. MS A. Begum, learned counsel for learned APP for the state respondent, on the other hand, strongly opposes the prayer for bail. Stop. She submits that there are materials available on record indicating that during interrogation, the name of the petitioners has come into light. Stop. She further submits that it appears that the petitioners, after burning the shop of the informant, has absconded, has been absconding, and because of which the investigation is not being able to take into its logical conclusion. Stop. Stop. Then you write. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears from the materials available on record that there are sufficient materials implicating the accused petitioners in the offence alleged. Stop. However, since they have been absconding, the investigation is not being able to proceed further. Stop. As such, the application for anticipatory bail at this stage cannot be granted. Stop. Accordingly, anticipatory bail is rejected. Yes. Disposed of. Yes. 39. It will disposed of. Yes, Daddy? Yes.
The FIR is at page 17, madam. There are two accused, madam. The allegation is that I have not paid the salary. The person who committed suicide, wife has lost this FIR. And Lordship may kindly use the key. Whether I have paid the salary or not, madam.
Yes.
Well, I am coming,
but because even if he suppose paid the salary.
My lord, fact is that it is as per the postmortem report, it is antemortem suicidal hanging that is there. At the time of inquest, my lord, there are witnesses, Gambura also there. At the time of nothing, no one, my lord, there. But while checking the mobile phone, there is a video of his own, my lord, prior to his death, my lord. At the video, my lord, he tried to say that, my lord, because of the, my lord, one Abhijit Barua, who is the, my lord,
accused number one.
Accused number clerk.
I am accused number two, madam. I am accused number two, madam.
Abhijit Barua misbehaved him. That is there, my lord. And regarding non-payment, my lord, Abhijit Korua, the accused number 1, he stated that at that point of time, he was a dumper driver.
He is what?
The site,
What driver?
Driver of dumper, dumper vehicle, malad. And malad site has been changed. Now they asked him to come to Guwahati if he want to continue. He refused to come. And another thing is that earlier
Parashar, any adverse material against petitioner?
He is.
So we are considering the anticipatory bail for the petitioner. If there is
the
nothing,
owner of the
that's right.
On the video only regarding that
petition, accused one.
Accused one.
So this is not accused one.
I'm too malo.
39, okay. Heard Mr. S.P. Das, learned counsel for the petitioner, stop. Also heard Mr. K.K. Parashar, learned APP for the state respondent, stop. This is an application under section 438 of CRPC for grant of pre-arrest bail to the petitioner, i.e. Arnab Chaudhary, who is apprehending arrest in connection with Dhokwa Khana PS case number 148 of 2023, registered under section 30634 IPC, arising out of FIR lodged by Srimati Moshami Borwa, dated 29/12/2023. The facts of the case is that on 29/12/2023, an FIR was lodged by the wife,
yes,
by the wife of the deceased, alleging inter alia that since her husband, deceased, did not receive his salary for last 23 months from the FIR mentioned accused number 2, and upon asking his salary, the accused number 1, the present petitioner.
No. Is one of number 2.
The accused number 1 drove him by threatening and beating. Stop. Thereafter, he committed suicide by recording a video wherein he stated the above. Correct? Stop. OP, where you said accused number 2, there within bracket, petitioner herein. Mr. S.P. Das, learned counsel for the petitioner, submits that the petitioner is the owner of the vehicle of which the deceased was a driver. Stop. He further submits that there is no pending salary required to be paid to the deceased. Stop. This is his submission.
Yes, and in the CD bank statement of the disease also available. Up to September, 10,000.
Whose statement?
Of the disease. Bank statement
of the deceased?
Of the disease.
How that statement is available?
Bank statement of the...
bank statement.
Bank statement.
Then you say that Mr. K.K. Parashar, learned APP, submits. Are you opposing the prayer?
Bank statement shows that
fairly submits on the basis of the materials available in the case diary that the bank statements of the deceased shows that he has received salary up to September 2023. Stop. He further submits that the video recording of the deceased prior to taking his life indicates that he has stated that the co-accused had threatened him and had refused to pay the salary. Stop. considering that there are no adverse materials available at this stage against the petitioner, against the present petitioner, this court is of the considered view that custodial interrogation of the petitioner is not justified for the ongoing investigation. Stop. Accordingly, it is provided that in the event the petitioner named above is arrested, is allowed to go on pre-arrest bail, bail bond of rupees 15,000, satisfaction of the arresting authority, and appearance 7 days. Subject to conditions, appearance 7 days, inducement. With the aforesaid observation, the anticipatory bail application stands disposed. Okay, we followed the last part. 40 awaits CD list on
Talukbadi Malat
19/3/2024. You are on. This is anticipatory bail.
Lordship, this
19th. Yes, next. Mr. Parashar.
But I want to submit.
Yes.
Yet 65 is there, 66 is there. But I did a girl, yesterday the girl had appeared before the.
Very well. You have it
let us
on
see
next
the-
week. When can you have it?
19 I have said, Malad.
19?
Oh, after tomorrow.
19th.
Talukbari Lord.
Yes. Next.
Is there is there?
Yes, Malad. FIR Lordship will find at page 73.
Page?
73, ma'am.
Yes.
FIR indicates that on the same issue, there are 2 cases pending.
Yes.
One is PS case number 74, another is 75. I have stated in my.
Were you on interim?
No, ma'am.
Yes.
In fact, I am participating in those cases, my lord. Same FIR. There are 4 FIRs, my lord.
Land dispute.
Lordship. 4 FIRs. One is at case 38. It is dated 25/2017.
Allegation of land grabbing.
Lordship. Then, my lord, in between is 2 sets of, my lord, one set of FIR is of 2017, another is of 2023. In between, my lord, the informant filed a civil suit. That lordship will file a case. When I was, the petitioner hearing has been arranged as defendant number 2. Same issue. Then he withdrew the case. And the other trial court gave her the liberty withdraw without that lordship find that fees. No liberty was granted, 64. Thus, perhaps he filed the subsequent affair. The order lordship find at page 65. Prior to that, my lord, the petition she filed. I filed a written statement.
That was withdrawn.
That was withdrawn, but liberty was not granted. That was withdrawn on 28/3/2023.
He withdrew the petition whereby?
He claimed, my lord, this same dispute.
That petition was withdrawn.
That petition was.
Okay.
And liberty was not granted. That is why, my lord, she perhaps filed this FIRs, my lord. One is of first FIR is of 27/11/2023. Subsequently, after this, my lord, she filed another.
Who are you? You are the purchaser, or you are the?
I purchased, my lord, once. It was during, my lord, 2009. 2008, my lord, the informant executed one power of attorney to someone. And that power of attorney, that power of attorney, I purchased that land, 2009. And subsequently, my lord, I sold it in 2 parts. That part is over, my lord.
All right. Yes, Mr. Das.
The landlady had 15 bighas of land, FS land. Example land. Out of that, he already sold 55 bigas. No dispute about that. Remaining 10 bigas, what happened? These persons, Mansoor and Amrul Islam, two persons.
Who is the petitioner?
The petitioner is Mansoor.
Mansoor Ali, yes.
Mansoor and Amrul Islam, in collusion with one Konkon Deka Soikia. Or in the name of Konkon Deka Soikia, one forced power of attorney was executed by impersonation. Presenting one different lady, he got executed one power of attorney. Then this Konkon Deka Soikia sold the land to Mansoor.
So there are specific allegations attributed against the petitioner. Petitioner is the one who had forged the documents. See, there is no yes here because these are the materials that has been collected by the investigating officer, and we are considering only whether we will grant, this court is going to grant you anticipatory bail or not, correct? This court is going to go by whatever the materials are available and exercise its judicial discretion. We are not going to the merit of all these, whether these allegations are true or not true. Of course, if there is prima facie something is evident, we shall judicially take notice of it. Yes, Mr. Das.
Then, my lord, this Mansoor sold in two parts that land to one Samsul Rahman and one Subolde. Now, my lord, Samsul Rahman came to know that something is wrong. Something is wrong. Documents are forged. That is why he made the original owner. Again, he repurchased from the original owner. And thereafter, this Konkon Deka Soikia, he died, who was purportedly should be that a power of attorney. So, with all respect, I submit, this is not a case of anticipatory bail.
You want to add anything?
My lord, you will find it piece 8. What was the subject matter of the civil suit?
We are not going into that. Civil suit going on, whatever is happening, we are not getting into it. Appears that there are materials at this stage and it is for anticipatory bail. Now the question is about your custodial interrogation. Since the investigation is at an active stage, this is not a case. The element of criminality is prima facie evident. Anyway.
FIR itself is indicative of the fact that there are parallel cases that are pending. The same subject.
Heard Mr. UK Goswami?
Sharma.
Your name is not here.
I'm not.
Mr.
Ash Sharma.
Ash Sharma, Learned Counsel for the petition. Stop. Also heard Mr. D. Das, Learned APP for the state respondent. Stop. This is an application under section 438 CRPC 1973 for granting pre-arrest bail to the petitioner, i.e. MD Mansoor Ali, who is apprehending arrest in connection with Pragjyotispur PS case number 157/2023 registered under sections 120B/447, 34/206/466, 465/468, 471, 472, 294, 506 of IPC, within bracket GR case number 8806 of 2023. So, the case of the prosecution is that FIR is at page
B73.
Is that on 29/11/2023, an FIR was lodged by the informant stating, alleging inter alia that on 27/11/2023, don't say that. Alleging that inter alia that she has a plot of land measuring 15 bigha, out of which she had sold 5 bighas of land, and the remaining 10 bighas of land is still in her name. Stop. it is further alleged that some people encroached into her land and instituted her land, for which she had instituted a case in the Guwahati High Court and Panikheti Police Station. Stop. Pragjyotispur PS case number 74/17 and 75/17 had been registered and the petitioner herein along with two co-accused were arrested. Stop. There they had got bail? No.
Yes, ma'am. Yes, sir.
Now it is further alleged that those two cases are under trial before the Honorable Court. So this FIR is in connection with the same.
No, bro, the specific section regarding that remaining 10.
No, it says here also, while some people encroach my set period patta land. The same it appears.
Civil suit.
Civil suit. And then what about those two PS case where trial is going on?
There are 7 have stated.
So, is it that though she has about another 10 bighas of land in respect of different areas, various sales have been taken place? One plot. So how come two cases then, Mr. Das? Mr. Das, you do one thing. Please take instructions on this. As regards the other two cases where trial is going on, we'll have this day after tomorrow. We are not.
In paragraph 7 and 10.
Let the additional public prosecutor take instructions, because you see, if they are related to the same offence where he is already on trial, then of course this court will have its own reservation.
These kind of cases are concerned, my lord. Trial, even searches are not filed.
No, but
I am dealing with most of the cases.
Mr. Das, you just take instruction whether PS 74 and 75 is in relation of the same land for which this FIR is also filed. Just that much of instruction. All right. We have it day after tomorrow.
My lord.
You say list this matter. You cancel that order. List this matter day after tomorrow.
PS 74.
You give him those two numbers.
Give him the.
CD?
Yes, they received, my lord.
Yes.
Page 15, you know, 711.
Yes.
Page 15. The way case has been projected, my lord. But the minor obtained this.
Injury report there?
Oh, no, my lord. Injury report is not available in the.
When can we have it? Injury report will be required, his head and all.
Yes.
Anticipatory bail?
Yes, my lord.
When can you have it?
My lord,
Next week?
number.
Monday?
Yes.
Monday. The case diary produced before this court does not have the injury report. Stop. Call for the same. List on Monday. Date. Hope you give the date, huh? Yes. Yes. Await CD. List this matter. Date.
28.
28/3/2024. Are you on interim? No.
No.
All right. Yes, why is this revision petition for orders? Why has it come for orders?
Lordship, my senior is on court.
This question, this court is not asking you that question as regards where your senior is. If a matter is placed for orders, it will be placed for some reasons. So, as a counsel, you must look into the record and see why has it come. Await service report. Is service completed? You counsels, you must look into the office note and assess the court. Office note dated 7/3/2024 indicates that the service in respect of the sole respondent no, you say like this. Office note dated 7/3/2024 indicates that the AD card in respect of the sole respondent has already been received after due service of notice with full signature of the recipient. Stop. Into X2 code down. R2 file it as what is the sole respondent's name? Yasmin Begum. Yes. As such, service is completed. List this matter for admission after 2 weeks on a date to be fixed by the registry.
Earlier items 67 million. The date may be 20 million. Interim is not there.
20? 20. In item
67.
67 OP, the date will be 23.
20.
42.
Service.
42.
Item 42 and 46.
Name shown.
Yes, Mr. Prasad.
My lord, I filed an application IA under section 389(2) for suspension of the sentence and execution along with the criminal act. I have been convicted under section 6 of
The report of the FBI is going to be sent in a day or two, and accordingly 6 posting of this matter on Friday. Stop prayer allowed. List this matter Friday date.
Till then, my lord, may I pray, my lord?
Next.
Interim Jimma.
No, next. There was, I think, a mention of item 45 in the morning. You mentioned? When do you want it?
The date may be fixed.
All right. As prayed for by MS, you are RR.
I'm P. Ghosh.
P. Ghosh.
On behalf of RR.
You are R, respondent number 2.
Respondent number.
Why are you all standing in the wrong sides?
I am respondent number 2, my lord. I have filed an IA for which I am an applicant for that opposite party.
As prayed on behalf of Mr. As prayed by MS T. Ghosh on behalf of MS RR Mujib, Learned Counsel for respondent number 2, which is not opposed by the Learned Counsel for the petitioner, list this matter on
2nd April.
2/4/2024.
Oblige.
Yes.
Lordship, as per office dated 2/2/2024, service awaited.
Service awaited. Await service report. List this matter after 2 weeks on a date to be fixed by the registrar.
My lord,
Registry.
in time appeal may be admitted and record may be called.
Next.
Oblige.
Criminal revision petition. Why is this listed?
Service is awaited.
Service awaited. Await service report. List this matter after 2 weeks on a date to be fixed by the registry.
Item 70.
Steps by way of Dusty, has it been taken?
This is the
You are appearing?
joint petition filed by the.
This is a
joint petition filed by the victim and the accused for lordship quashing of the criminal proceeding. As they have already lordship entered into marriage, they are lordship living as together as husband and wife. The case lordship is an argumentation. The argument is fixed on 14 lordship. They have to. My lord, this is the case lordship.
Where is the prayer, and it is jointly filed?
My lord. Charge has been framed under section 376 and 506.
Case is at the framing of charge.
Already case is argumentation.
Arguments.
My lord.
Now you want that proceeding to be quashed.
So far the petitioner number 2 is concerned. There are some other requests lordship in respect. Two lordship girls were
You want the
kidnapped.
proceedings in respect of accused number 2, petitioner number 2.
Number 2, lordship and petitioner number 1 is the victim. Well, 2 girls were kidnapped, alleged to be kidnapped by the accused lordship. There are some other accused. 4 accused trial is going on against 4 accused. I am only for the 1 accused. 1 girl was minor.
This is a non-compoundable offense, isn't it?
Yes.
Mr. Parashar?
366A, 376 of POXO.
No, POXO is in respect of case 18, your lordship.
Live streaming to Bonko.
Foreign women lordship is 18.
Yes.
Charge so for the present
Being an old pending case, the records have been misplaced and accordingly take some time for reconstruction of records. Prayer allowed, list this matter after 2 weeks on a date to be fixed by the registrar. There be time, Mr. Kotoki?
It's actually IA has come for consideration.
IA?
But, it has not been disposed of as yet.
48, what is otherwise listed as the criminal appeal.
So, the case on the POSCO Act, my lord.
Treated as the
Yes,
FIR.
my lord. And then, my lord, on that faithfully police officer who had filed the charge.
Who had implicated a Maruti car.
Yes, 20 and 120B. 120B and 420. I joined the police station at a later.
All right, what is your case? Tell me otherwise what.
Otherwise, my lord, I am a government servant there. First of all, my lord, my implication comes, but strangely enough, no FIR was filed at that only issued the police report. Exhibit 1 showing the Maruti car as the offending vehicle in place of an unknown truck, which in fact caused the accident and managed to run away. For the aforesaid reasons, I am not inclined to grant any compensation to the claimant and the claim stands dismissed. That connection with the cases concerned is 23/9/2006. In 7
date of occurrence.
Yes, madam. PD entry to that effect. FIR was lodged. This case 127 of 2006. Yes, madam.
At 11. Which says finding of the inquiry, what is not understood is mistake. And that has then the.
So during the report just one thing, madam. I was not there, madam.
So that you are not there.
No, madam. Page 18, madam. Page 18, kindly see. This is an order passed by this honorable court in my bail petition, my lord. There the CD. I have perused the materials available in the case.
Yes, yes.
Produced by the so in the statement of the petitioner recorded at section 161 CRPC, the petitioner has taken a stand that after investigation of Dhola police station case number 127 of 2006 was taken over by him subsequent to transfer of the earlier investigating officer, he interrogated the driver of the Maruti car and during such interrogation the said driver had admitted about the accident. Without examining any other witness in that regard, he stated to have submitted the charge sheet in view of such statement of the driver. As the petitioner appeared before the IOP, then this was in this CD. So, on our submissions, my lord, the records were called for, my lord. And the learned PP, my lord, they sought for time to go through the records and then for their submissions before this honorable court. So, your lordship may examine those records, my how I came in and but this is a finding from this court because I came at a later point of time. I came at a later point of time and that Maruti that happened I took statement, man.
Have you seen the records, Mr. Das? Then we'll have it on another date. You look into the records. When can we have it?
My lord, I prefer short term because
Day after tomorrow, my lord. Day after tomorrow. If possible, my lord. Time is
Goswami?
14.
14, another case has
Yes,
just
yes.
been fixed.
My lord, my lord.
Next
My lord.
week Tuesday.
Next week Tuesday.
Next week Tuesday, not our next week to not our next week to.
can it come as a fixed case?
After 14 at a hearing date. 19th Daru matters. 21st? List this matter on 21/3/2024 for further hearing. In the meantime, Mr. Das, you have a look at the LC.
In fact, I went.
No problem. Because since these records would be relevant, and
I had checkmarked also.
just check because otherwise.
My lord, case is, my lord, I'll just, my lord, elaborate in the 21st.
All right.
Much obliged.
50? It would ask in negative. Interesting,
Quashing.
What is this?
Well, the quashing of the cognizance order and the thing, my lord. The
It'll take some time.
it will take some time.
We have it on another day then. Hearing date.
Can it fix on next Tuesday? Or Thursday? Hearing date?
21st?
Yes, Thursday. Thursday.
21st, I may not be, my lord.
All right. Suggested. Tell us a date, Mr. Bora.
Thursday.
20.
28 is, I think, a hearing date.
28.
List this matter for further hearing. 28, 320.
For hearing, my lord.
Yes, I've said for hearing.
Interim.
Interim, if any, shall continue till then.
Is it criminal, government criminal appeal?
Yes.
File against the acquittal, my lord.
You are for the respondent.
For the respondent, we have been acquitted under charge under section 7 of the PCA.
Are you prepared, Mr. Das?
Actually, our paper book is necessary because otherwise it's a voluminous record. You all have seen it.
We'll direct the registry to prepare
Yes,
a
otherwise it's
paper.
difficult, my lord.
You're right. That it is submitted at the bar that since the papers are voluminous, since the records of the court trial court is voluminous, a paper book is required. Stop. Let the registry prepare a paper book and place this matter for hearing, with supplying copies of the same to the respective counsel. In item 54, you said registry to reflect the name of the state council in the cause. Yes, Mr. Das.
Why not this matter was fixed for hearing? Come in due course, ma'am. Yes, I don't know.
As paid for list this matter.
The date may fix on first week or second week of April, ma'am.
In the list this matter in the month of April on a date to be fixed by the registry.
And interim is there, ma'am.
Interim, if any, shall continue till then.
Highly.
Yes.